What if there had been some conversation where Alan had sat down and told everybody, this is what I want, this is the way I want it? There would have been no surprises at his death. And even this inconsistency might have been waived by the person who would have been the beneficiary of it when they know, and they know everyone else knows, that it's perfectly clear what their dad intended.
Life's Third Act is a podcast dedicated to helping you get the most out of your retirement. Sponsored by Tucker Allen. Here's attorney CPA Joe Cordell.
So we're back today. We're picking up with part 2 of the life and estate of Alan Thicke. If you've not watched part 1, I encourage you to go back, look at it first. And today we do part 2. I hope you enjoy it and learn a lot. It's uncanny that what you were describing, that this guy was asking about his health, and that he would have had this intuition, because you don't look at this guy. If you were a phony medium, you would not think, I'm going to go to this guy having a sudden death soon, because he looked pretty athletic, and this guy had aged well, and it's not shocking that he was playing hockey, except when you throw in the fact that he's 69 years old. That was just uncanny, that whole thing.
It was crazy. I was watching that because I remember I was just looking up like biography videos on him, and I ran across that and I clicked on it and I started listening to it, and I was on another tab reading something and I wasn't really paying attention, and then I tuned into it finally and I was like, are they talking to a medium right now? And then it like switched over because the wife had come back in 2 months after Alan's death to like talk to him, and I couldn't get away from it at that point. I was like, I have to watch this thing in its entirety.
It draws you in. And she was on a talk show with the medium, and this may have been sometime after his death, describing what had happened, and just amazed that he could have seen it. She believed in this guy. Now, I don't want to suggest I believe in the capability of people doing this sort of thing. I'm a skeptic. But I am impressed with the coincidence of this. So getting back on track with the estate plan, this was a sudden death. So there wouldn't have been last minute preparations, and yet I do think that probably with some regularity, Alan updated his living trust and his other components of his estate plan. But I don't think that he fully appreciated the inner working necessity of this and his prenup. My guess is that there were different lawyers involved, because if they were the same lawyers involved, I'm sure that they would have made sure that these documents, which they'd probably be looking at in the same file, they would almost unavoidably coordinate these provisions. It would be shocking if the same law firm did all of this. So I think what happened was, and this is not uncommon in the real world, is you have some subject matter that falls between two chairs, meaning that you have lawyers who are estate planning specialists. They're the ones who all they do is estate planning, and that's who you want to go to. You want to go to an estate planner. But incidentally, in the law in many states, Missouri is one of them, you can't call a lawyer a specialist. It's not like medicine. In other states, though, you can get certified as somebody who is a quote-unquote specialist. So when I use that word, what I mean, though, is simply whether called a specialist or not, there's somebody who only practices that area. So just like a physician who would just do surgery. So they only do estate planning. Well, as you might guess, as you probably know, that when it comes to family law, domestic relations, the best are the lawyers who just do that. They don't do anything else. I mean, they practice domestic relations, period, all day long, every day that they're working. This is what they do. So these are the two chairs where you think, okay, I have this matter involving a prenuptial agreement. Who do I take it to? And most people do not think, maybe I should take this to my estate planning lawyer. They don't, because they think, well, that's for my trust or my will. And many will end up going, and for which there's a good argument, will end up going to a family lawyer or a domestic relations lawyer. So that's fine, but keep in mind that unless either of these two specialties, unless they have stretched to know something about, for example, on the estate planning side, unless they've taken the time to know about what's required in the case of a divorce, what are the provisions you need, if that's what activates this agreement, it may turn out that the expertise in your will and trust is irrelevant because the document comes into play because there was a divorce, or vice versa. So you go to the divorce lawyer and you say, I want to be sure that I'm bulletproofed in the event that my marriage comes apart, so I want a prenup that deals with that. Well, hopefully that divorce lawyer will have sufficient knowledge about the estate planning issues to be able to incorporate that. So you can see how easily, this subject, this concern for the client falls between two chairs. And my suspicion is that that's what happened here, is that, I don't know this, but I suspect Alan Thicke probably went to a domestic relations lawyer the domestic relations lawyer, it's not that they couldn't know anything about what's required in the case of death that this document is to apply to. They could reach out and know it for those purposes, just like it's possible for the estate planner to know enough about what's going to happen in divorce to be able to think through those provisions, or at least be able to handle those provisions too. And then you can always have a lawyer, you can ask that the lawyers coordinate and work together, which is the ideal. And it may not really push up fees because they're not necessarily duplicating work. There'd be some additional costs when you use the two other than simply double. So there's some inefficiencies, but not a lot. That would be the ideal. But anyway, I think what happened was these two documents didn't get synchronized because they were drafted by different lawyers, different law firm even. So what happens when you have different provisions that are to happen in the event of death, and there are two quote-unquote governing documents? Well, that's a question that, as you might suspect, can easily lead to litigation. And I can bring up here a comparison of what some of the issues were that arose in terms of the conflict of terms. And this is just a partial list from what we gleaned. One was on the ranch property, there were several pieces of real estate. There were at least two. And at the time of his death, it may have been only those two, because we think that there was another house that had been sold. So regarding this ranch property, which was 11 acres, it also had a house on it, a ranch house. And this is in California. It's called the Carpinteria Ranch property. So the prenup agreement said that Tanya would get 5 of those 11 acres. Well, the living trust said that the ownership for the entire 11-acre ranch went to Alan's 3 sons. There are also percentages that were applied to the estate. And some of these percentages were only to apply to what's left of the estate after these specific gifts or bequests, and others appeared to respond to or to apply to the estate as a whole. So anyway, the prenup agreement allocated 25% of Alan Thicke's entire estate to Tanya. Not unreasonable. 25% is significant. But the living trust granted Tanya 40% of the remaining estate after specific allocations. So the specific allocations included things like the 11-acre ranch going entirely to the kids. So the math could easily have worked out to where, though that said 40%, it was actually less than the 25% that seemed to apply to the whole estate. Right to reside at the ranch. Both of the documents did allow Tanya to reside at the ranch, though they had different provisions about paying the costs associated and the maintenance thereof. Personal effects. The prenup agreement gave Tanya 25% of Alan's personal effects because it was that overarching 25%, whereas the living trust allocated most of the personal effects with specific reference to Thicke's 3 sons. Life insurance. The living trust specifically mentioned a $500,000 life insurance policy, which was in effect at the time, by all accounts, as well as his union pension and death benefits. There was no provision of this at all in the prenup agreement. So if the 25% that was mentioned in the prenup were to apply to the entire estate, then it would have picked up, of course, these. But if, in fact, it was not intended to apply to the entire estate, which appears to be the case, then you had assets that for all we know, Alan may have wanted her to participate in. Often, in fact, when you have a $500,000 life insurance policies themselves are notoriously or famously useful tools for providing a surviving spouse, for example, or a surviving business partner with the liquidity they need for support and not having to sell other assets. So I think it was just a failure to update the estate planning that failed to provide for this to be specifically mentioned as something to go to Tanya. But anyway, the community property rights, they were in California, so assets they had acquired jointly in the absence of a separate agreement would be shared 50-50. Now, most of Alan's wealth would not have been acquired during the course of this 11-year marriage, but some would. And the prenup agreement granted that Tanya certain community property rights, and others were clearly waived for purpose by way of the prenuptial agreement. So you can see how you can easily have a lot of provisions that clash, and in this case, because there wasn't coordination here, there was confusion. And what happens when there's confusion? When there's a stepmom and then her stepkids, it's an invitation to litigation. That's kind of the theme that runs through this series that we've been doing, focusing on conflict or failures in estate planning that are at root a result of failing to appreciate these dynamics between stepmoms, far more often than stepdads, incidentally, because of longevity issues, stepmoms versus the kids that are the natural children of the deceased dad. So this is one of those cases, but we've seen worse. This litigation that went on, it didn't go on for many years. It was wrapped up. From what I saw, I saw a court hearing 2 years after.
Yeah, it was fairly quick. I mean, I don't think the judge just wanted it on his desk anymore. He was like, I'm done with this. So,
well, yeah, and I don't think these kids had a long history of conflict with Tanya. Clearly, there were fractures there that came open after the death. And in fairness, even if there were good relationships, when you have documents like this that conflict, it is an invitation to disagree. And we're talking a lot of money here at, I would say, at least the $40 million estimate, but perhaps much substantially more. And so the provisions, all the efforts that Alan had gone to provide for his kids, to protect them and yet provide something for Tanya, this ends up being murky because of these very different terms. Now, the judge, in sorting this out, first of all, the judge dismissed a petition that the children had filed a document in which they alleged that Tanya's effort was to have the prenuptial agreement declared invalid. And apparently that would have had punitive measures for her. Without knowing the details of that document, I just know that her lawyers, and she was represented by Barbara Streisand's nephew, which keeps coming up, Adam Streisand, I think nephew. Anyway, he comes up a lot in representing celebrities in these cases where there's probate litigation.
Yeah, he does.
He must really be the best in that field, and we've read that before.
Because who was that? That's what I was trying to sit here and think about.
Yeah, he was in the middle of a real protracted litigation involving a big estate. But anyway, so Adam Streisand's his name, and she hired him. And he was very quick to make clear to the court and his responsive pleadings she was not making any effort to disclaim or declare invalid the prenup. So it looks like she might have done as well without the prenup, actually. But I think she was concerned about her reputation with the public, her image, and they had apparently a good marriage, and she just didn't want to be portrayed as, I think, somebody who was out for the money. So the court eventually issued an order in the case. The court found that, look, we're going to go ahead and we'll do a division of the assets largely based on a percentage with a few things set aside. And so the big picture was that the judge set aside, it was 60% of the total assets for the boys, which ends up being 20, 20, and 20% for each of the boys. And then 40% for her without, though, the 11 acres being included, although she did get to live on that. Or I don't know whether the part that she gives the right to live on included all of it. It may have just been the 5 or 6 acres that would have been most associated with the ranch house itself. So she would have an obligation to pay the expenses to upkeep it. But other than that, she would have the right to stay in this segment of the total ranch of 11 acres. And the rest went to the boys. So it seemed like a pretty reasonable result. The court allocated some personal property as appropriate. I think the $500,000 life insurance policy went into the general pot. Another thing that would have resulted in some disagreement here too, and was the source of the testimony that led to the judge's final decision, was also payment of taxes. It's an important thing to think about whenever you're doing an allocation of assets, because the way that the non-probate assets statutes work in most states is that they will first take the taxes associated with the estate and bring those against the money that is in the probate first. And then when that's exhausted, then it can go to assets that are called non-probate, things that did not actually end up in the probate estate because they're, for example, in a revocable will. But they resemble stuff that should have been in the estate because it wasn't a true transfer, in that it wasn't an irrevocable trust that was created. I mean, when you truly transfer something, then it's not generally, absent fraud, it's not available for the court to say, we're going to pull this in to pay estate taxes because it was truly transferred. It's no longer yours when you die. But a revocable trust is more of the nature of something that continues to be yours. You have full control of it, even though you may have your assets transferred into the living trust. For estate tax purposes, the IRS, as you might imagine, is not going to allow you to have your cake and eat it too. So it's part of your estate for estate tax purposes. Interestingly, though, where it may go into the calculation of the estate tax, but the estate tax payment itself is going to come, depending on, it varies from state to some extent, but I'll tell you what's most common is a provision that says those expenses will first come from the assets that are in the probate. And then if you don't have enough money there, then they reach out, kind of a clawback sort of, to the assets that were in the revocable trust or other non-probate asset. So you can see how that could have a pretty dramatic effect when you're talking about a $40 million plus estate. So there may have been, let me issue one other disclaimer too, as I do often when we're having these conversations, is that people may have created, especially when they're very wealthy, may have created irrevocable trusts. So there may be some assets that are beyond the course of this conversation. It probably is true, though, that this surviving spouse, Tanya, was not a beneficiary of those. Those are typically created, I suspect, before near the end of his life, maybe many years ago, in order to take true advantage of these sorts of entities for tax purposes. So it could have been created in the 90s, could have been created in the 80s. But those are assets we won't know about because they're not going to be available to the public in any way. We don't know that they exist. But the revocable trust gets drawn into the litigation and discussions about it. So we know a little more about it than we know about the other because of the litigation. And the will, of course, we always know anyway. So in this case, we do know that part of the reason there was conflict and disagreement between the parties was resolving how do you take care of this tax matter. And I think the judge ultimately decided that we pay the taxes first out of all the estate, and then we do this division of 60-40 that we discussed with the modifications of the particular assets we've mentioned. And the ranch, incidentally, is a valuable asset, and it was clearly going to be owned entirely by the 3 boys, but with the wife Tanya able to live on this 5-acre tract. But the judge was going to assure that the hardship that might otherwise have resulted from the payment of taxes, was remedied despite the failure to coordinate these 2 documents. So this is about as good of an outcome as you can ask for. There wasn't a whole lot of litigation. It didn't go on for what we've seen we've seen, among the cases we've talked about on the show, 2 decades of litigation. James Brown's went on for a long, long time. Elvis, of course, is infamous. It reaches into a next generation. So in this case, I'm very impressed with Alan Thicke. I'm impressed with him as a great father, very devoted to his children. He handled his money well. There's no indication he was wasteful. He was always prudent in his investments and made a lot of good decisions. That's the reason I suspect the number that was there at his death was substantially north of the $40 million estimate. And his wife and children, there wasn't the sort of conflict we often see, but it was just, I think, almost inevitable that when you have this estate planning that went wrong, despite Alan Thicke's best intentions, he just had a failure, point of failure that was calamitous potentially when you don't coordinate a prenup and an estate plan. That's just a failure that can go to the heart of an estate plan. But in this case, it turned out, I think, probably not greatly different from what he would have liked. I'm sure he wouldn't fully approve of what the judge here did. That you never do. We don't want judges to make these decisions. But I think that he did want his wife to have something significant, and she got something significant. A couple other comments, though, I'd make as we wrap up here that I think could have been handled different. The biggest is I've mentioned already, but it bears repeating. Coordinate any prenuptial planning or any other document you have that's going to impact your estate plan. Be sure that the same lawyers look at those documents. Communication. This is a recurrent theme that you hear a lot, but it bears repeating. What if there had been some conversation where Alan had sat down and told everybody, this is what I want, this is the way I want it? There would have been no surprises at his death. And even this inconsistency might have been waived by the person who would have been the beneficiary of it when they know, and they know everyone else knows, that it's perfectly clear what their dad intended. It really places a lot of pressure on the party that's going to exploit an opening. Like a mistake like this is always an opening for one side or the other of the table. It might have served to prevent any conflict. Certainly, it would have appeased some of the parties about what was fair and just in terms of their dad's reasoning. So we mention this a lot. I can just tell you, people don't do it a lot. I'm willing to bet you've not done this a lot. It's not pleasant. Nobody wants to do it. Tax burden implications. Mention that. Huge issue. Think about it when you're doing your estate plan allocation. And then also, if there are life estate or other, I used a legal term here, possessory interests are included, you need to anticipate the disputes and abuse that might happen. In this case, there is a remainder interest and a possessory interest. The remainder interest means that as to this 5 acres that Tanya gets to live on, that the boys have what's called remainder interest. When she dies, it reverts to them. She only has the right to live there and use the property and to use it reasonably and without waste, et cetera, for the balance of her life. So the boys can expect that that's going to come to them someday, and as a result, they want to be sure that the way it's handled in the meantime is reasonable and that there's reasonable upkeep and that there's not deferred maintenance, all those things that can happen when someone chooses not to keep up something in which they're possession. So the possessionary interest, though, is hers. So sometimes there will be conflicts about whether the boys can come onto that for ancillary activities, like it is 5 or 6 acres. So it's easily that they would have activities that they'd be engaged in, commercial or otherwise, that could impact that acreage. So what are the limitations of their ability to come onto the property? These are things that often when a life estate is awarded, there's no detail about who's responsible for the maintenance and upkeep. If there's no mention of it, there's a reasonable argument that the nature of some upkeep should fall to the person living there. But just like if you rent a property from a landlord, that's a very similar thing. You have a possessory interest on one side of the table, and you have the ownership interest on the other side of the table. So the concept's the same. Well, you think, well, gee, if I break something, or if something's wear and tear due to me, yeah, I should probably replace that if I'm a renter. But what if the roof leaks? You may say that if you're the renter, wait, I shouldn't have to fix that. Or what about taxes? Why would I pay property taxes? I don't own it. So these are the sorts of things that if you leave unmentioned and you give somebody the right to continue living in a property or continue using a property, you've got to think through how do we allocate these responsibilities. And in this case, apparently, there was no or very little provision for some of these. The judge cleared that up in his ultimate decision. Choose trustees and PRs with both good judgment as well as a capacity for fairness and diplomacy. This means that you want to place someone in a key role where you have parties that you think have the potential for conflict. And in this subject matter that we're doing in this series, you do have that built in due to the natureship of natural children and a stepmom. In that case, you want to place someone in positions of decision-making regarding shared interests that will be sensitive to the requirements, the expertise, the personalities of both sides. It can make or break whether you end up consuming 25, 30% or more of your estate in costs of litigation, where the trustee or the personal representative, is spending the next several years of their lives shepherding litigation through the courts. And, of course, the money is paid out of the fund of assets that would otherwise have been available to the combatants in this litigation. So the way to avoid that is one way to at least minimize that risk is to have someone in the decision-making chair, whether it's a trustee, PR, whatever role it might be, where they are sensitive to the relative interests of parties and they're more likely to be a peacemaker than to be very adamant, inflexible, intolerant of compromise. We know those people. We all have them in our family. I'm wondering, am I considered that person? But sometimes the lawyer gets accused of being that person. The lawyer doesn't have to be that person, but they might be. So think about who it is that you have in those key positions where you have shared interests. That can keep it out of the courts just in and of itself. A blended family scenario, minimize terms and conditions requiring cooperation and agreement. This is kind of the counterbalance to the point I just made, and that's that, look, while it's good to have somebody who can shepherd these conflicting concerns in a way that this great, good judge, it's even better if you can come up with an estate plan that requires no cooperation. That does a division of assets or interests in such a way that neither party is required to cooperate on anything with the other. That's the ideal. And to the extent that you can have no co-ownerships of businesses and other assets, that's the ultimate solution. And when you invite parties to share as partners in some capacity, as joint decision makers in some capacity, even co-owners, whether or not they're joint decision makers, it's inviting litigation. A co-owner can still bring litigation even though they may not have any authority to make decisions about what they own. They have a right that they can take to court. So where you can, eliminate the possibility in that way. Choose the division of assets to reflect that criterion. Finally, something I mentioned briefly, but life insurance, when affordable, is a hugely valuable tool in estate planning. That is the means to address, for example, the point I just made. That is the means to pay off somebody, to take care of them in the way you want to, like a surviving spouse is a classic example. You want to take care of this person, but you don't want to have to sell assets to do it. And notoriously what happens when in a case like this is that in order for you to take care of her, you may have to have a provision that says, well, she needs money. And yeah, we have a family farm, notoriously assets that I thought of that come into this under this rubric or this heading is family home is often a huge part of the estate. Farmland, which is difficult to market, at least in the short term, is often the primary asset in an estate. A family business, sometimes valuable heirlooms can be the most valuable asset in the estate. So when you have something like this, which is the dominant source of value for all the intended beneficiaries, then in order to take care of one, you either have them have to cooperate in some aspect, you keep the business and they share income, heaven forbid. So how do you solve this problem without selling the business? Well, you solve it by having life insurance. Life insurance is famous for this purpose since time immemorial. It's the way to take people out that would otherwise be a problem in sharing in the residual estate. So there was life insurance this kit, but I don't think it got to be fully employed because of this failure to adequately express what was to be served by that particular asset. Often there'll be a provision, incidentally, in a prenuptial agreement where the terms will be spelled out, and one of the conditions that will make this reasonable and acceptable, and perhaps is the incentive for the other party to sign the agreement, is that you have a provision that says, I agree hereby to maintain up until my death a policy in the amount of $500,000 or more at all times, and I promise to name as the beneficiary my wife to be, and she will reserve the right to inspect and confirm that this policy is good and valid at any reasonable time with sufficient reasonable notice. So she can confirm over forthcoming years that you haven't, neglected the premiums or failed to pay it. That's often a provision so that what might appear to be harsh terms in a prenup where you're saying, well, I don't want my wife to have any interest in this business that I have or any of the revenue from the business or anything that I might buy from the revenue of the business. I mean, those are all reasonable. I mean, if those are things that you've had and you're 60 years old and you're going into this marriage and these are things that naturally you wouldn't think that she would want to claim. But she may be thinking, well, look, I'm going to disrupt my life. I'm going to be living with you, and during the next 20, 30 years, maybe I would have gone and done something else with my life. I at least want to be sure that I have means to support myself if you die. So it's not unreasonable for a spouse to expect some assurances, and that's an example of the way to handle that. And I don't know that this $500,000 was provided for in the policy or in the prenup, and as a result, it came to existence at that time. But it's not unusual for policies to come in. Same thing when you're dealing with business partners for that matter, is to have a similar mutual provision where they each agree to a buyout, and that buyout is predicated on their each maintaining a policy from which there may or may not be funds that come directly from the company to pay for the policy. That relates to tax considerations. So I wanted to call your attention, though, to the life insurance here. We don't talk about it very much, but it can really be a centerpiece in making a great plan here, and it might have been intended to be a centerpiece here. So wrapping up here, so for the most part, I think that this was not what I would use the word good, because it clearly had a huge flaw, but it did reflect a guy who was trying to do the best, and it turns out the results I don't think were catastrophic, and nor would he have considered them catastrophic, though I'm confident he would say, if asked today and able to answer, say that it wasn't exactly what he had in mind. But for all we know now, the parties are getting along adequately. There's not much interaction that's required with this arrangement, and I think that Alan has provided well for his wife and his kids, and he could have done a lot worse, at least compared to some of the other lives we've looked at. So Alan Thicke, many ways an admirable guy. So with this, we wrap up the life and estate of Alan Thicke. I hope that you found this both interesting and educational. Keep us in mind, incidentally. Click the like button. Subscriptions are great. Let us know what you're thinking. Till next time, take care.
You've been listening to Life's Third Act, a podcast for thriving in retirement. Sponsored by Tucker Allen, your estate and elder law advisors. Each week, we discuss topics and answer questions to help you better plan for your future. For more information, visit tuckerallen.com. Subscribe and listen again next week for another edition of Life's Third Act. The choice of a lawyer is an important decision and should not be based solely on advertisements.